I will start the keynote session now. Thank you very much for still being with us after this long and very interesting day. We hope you had you had some very interesting sessions and productive ones as well, especially for the speakers. It is my great pleasure to chair this keynote by Nick Gill. And I will quickly introduce him for you, and then we will play a video of his keynote, and that will be followed by a Q&A. And as with the other sessions, you can always leave a question or comment in the chat throughout the keynote session, or we also accept it when you want to raise the hand during the Q&A, and you can unmute yourself and ask the question directly. Now, Nick Gill is a professor of human geography at the University of Exeter. Nick is a political geographer whose work focuses on issues of justice and injustice, especially in the context of migration, border control, mobility, and its implementation. Nick graduated from the London School of Economics and Political Science with a degree in geography with economics in the year 2000, and following the award of his PhD in 2008, he was a lecturer in geography at Lancaster University before joining the human geography team at Exeter in 2010. From 2015 to 2017, Nick was a trustee of the charity City of Sanctuary, which is a national charity that promotes a culture of welcome and hospitality to those seeking safety from violence and persecution. During this time, he initiated the Universities of Sanctuary stream of their work and remains on the University of Sanctuary steering group. From April 2017 to July 2018, he served as a member of the charity Justice, who had a working party on immigration and asylum determination reform, resulting in a report titled Immigration and Asylum Appeals, a Fresh Look, that recommends a series of improvements to the first-tier asylum and immigration tribunal in the UK. Nick was also involved in a partnership with the charity Asylum Aid, now renamed Consonant, to produce a video to inform asylum applicants in the UK about what to expect on the day of their hearing at court. And you can find this video on our ASYFAIR website. Nick's work also played a part in the High Court case between Detention Action and the Lord Chancellor concerning the legality of the detained fast track that led to the judgment that the detained fast track was unlawful in the UK. Nick's work is highly interdisciplinary, and he has published academic works in anthropology, economics, law, sociology, and migration studies, as well as in geography. He uses multiple methodologies and employs interviews, ethnographies, focus groups, and quantitative analysis in his work. And many of his publications are open access, and they can be found on the ASYFAIR website, most notably the open access edited volume with Anthony Good, Asylum Determination in Europe, Ethnographic Perspectives, which came out in 2018, and I'm sure most of you are familiar with. He's currently the PI of ASYFAIR, a multidisciplinary research project funded by the European Research Council. And this project examines access to justice in asylum determination systems in Europe. Nick will talk about some of the research findings from the ASYFAIR project. And again, I want to extend my thanks for Nick to having this keynote. And I'm going to share my screen with you.
Hello and welcome to the ASYFAIR keynote lecture for the ASYFAIR conference. I'm Nick Gill, the principal investigator of ASYFAIR. Thank you very much, first of all, to my researchers, past and present, without whom this presentation and the research that I'm going to talk about wouldn't have been possible. I'm not giving a paper today. I'm really just giving you a whistle-stop tour of the insights from the ASYFAIR project, the thinking that's gone into it, some of the thinking that's coming out of it. And my intention is to generate discussion, to pose some questions that are coming out of the project that are quite practical as well as conceptual. So I'll just share my screen with you. So to begin, what is an asylum appeal? An asylum appeal is a legal event that is intended to provide a check on the initial decision on an asylum application. It's an opportunity to have the case re-examined that's usually taken up by the asylum seeker, much more frequently than it is by the government, although it does happen that governments also appeal decisions. And who's involved in this process? Well, actually, it varies quite a bit. So it can be that the applicant is present, for example, but it can also be that the applicant's not there. The fairly constant feature is that there's a decision maker, but that can sometimes be a judge, it can sometimes be a panel of judges, and it can also sometimes be a decision maker who's not a judge. And then there are various other actors that may or may not be involved depending on the particular process in the country that we're talking about. Now, I'm talking about Europe and the European processes, but of course it varies even more widely globally. And one of the things that will be very interesting to talk about at the end in the question and answers will be how this process varies in other countries outside Europe as well. Within Europe, though, sometimes there are representatives for the applicant, sometimes not. Interpreters can be involved, experts, witnesses, supporters, the public, and then logistical staff like clerks and security staff. So it can vary quite a bit how this process is undertaken. And this picture is a picture of the UK process, where the judge is elevated, they're underneath a coat of arms, so there's quite a lot of symbolism involved. This is a picture of a tribunal, but through this talk, I'll mostly be referring to courts simply for simplicity. Why are asylum appeals important? Well, in 2015 and 16, over 1.2 million new asylum claims to Europe were received in both of those years, talking about the EU 27. And still in 2020, over 470,000 new claims for asylum were received by Europe. So one of the ways that we can think about how important appeals are is to look at the numbers. Now, these numbers are taken from Eurostat. The Eurostat figures are by no means perfect. And to be honest, we could spend a whole discussion and a whole lecture on the statistics that exist around the refugee status determination process in Europe and the flaws in those statistics. Unfortunately, I don't have time to do that in this talk, but just to flag that these are the statistics, the Eurostat statistics are the ones that I'm using here. Now, after the initial application for asylum, it's possible to appeal the decision under European law, and the number of appeals that were decided peaked after the 2015 and 16 peak in the initial asylum applications. The peak actually came in 2018 at just under 300,000 appeal decisions decided. And in 2020, there were still over 230,000 decisions made that year on appeals. So clearly we're talking about significant numbers of appeals. And the rate at which appeals are upheld also indicates their importance. Between 2017 and 2020, the rate at which appeals were upheld was fairly consistently around 30%. Now, this includes upgrade claims, which means claims to improve one's status, even if you've been granted a certain amount of status at the initial decision stage. But the 30% represents quite a big increase on earlier in the 2010s. So in 2011, 2012, and 2013, we were looking at more like around 16% in those years. So the statistics indicate in various different ways that the appeal process is important. And the right to appeal, the right to redress against a government decision that affects you profoundly, is also written into international law, such as Article 8 of the Universal Declaration of Human Rights. Everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted him by the Constitution or by law. So not only statistically, but also legally, these are important processes. Now, how have they been studied so far? Mostly, asylum appeals have been studied in a legally doctrinal way, and that's fantastically important and productive. We need to know what rules apply to granting of asylum, and it's been a sticking point in Europe, as you all know. There's a lot of disagreement and discussion around what the asylum rules should be, under what conditions should asylum be granted, and also the procedural rules around when and how asylum should be granted, how the decisions should be made. It's fantastically important work, and it's fair to say that the majority of attention that's given to asylum appeals is from this kind of legally doctrinal tradition. But there's also empirical work that looks at asylum appeals. For example, there are a number of statistical studies that look at appeals, and the strength of the statistical branch of work that looks at asylum appeals is that it's able to identify inconsistencies. For example, inconsistencies in the rate of success of appeals, even within countries, or certainly across countries within Europe, even within particular nationalities. So holding the nationality of applicants constant, statistical work is able to demonstrate that there's high variability in the likelihood of success depending upon the country that claim is determined in, depending upon even the region and the judge. And there's some fantastic work, a very famous study from America called Refugee Roulette, that also shows these types of variabilities. Now, one observation about both the legally doctrinal work and the statistical work is that they're both desk-based. The researcher doesn't tend to go to the hearing and watch it in person. Now, that's where our research differs. We have gone to the hearings, we've watched them in person, we've watched quite a number of them. And one of the premises of the project, the ASYFAIR project, is that this generates a particular type of data that can be useful. Quite a number of authors writing in this area have expressed concern that the appeal process itself is black boxed, meaning that it's very difficult to work out what happens during these processes. It's not understood in a practical, concrete, on the ground way. And what we're interested in ASYFAIR is what goes on a day-to-day level within hearing centres and court centres that are hearing these asylum appeals. We want to know about their geography, because they happen somewhere. They always happen somewhere. They always happen sometime. We want to know about their sociology, because they always involve somebody. So there's power dynamics, there are communication dynamics, and they happen in particular settings. So these are the types of perspective that we try to develop in the ASYFAIR project, which are very much complementary to the existing empirical work and legal work that's already been undertaken. We don't see them as substitutes at all. It's just a different complementary lens onto the same process. So our research aims during the ASYFAIR project are to understand the practical grounded challenges facing asylum appeals as an effective form of protection. We aim to examine the roles and experiences of various actors involved in appeals, including appellants. We want to understand the different ways laws are interpreted, implemented, and negotiated on the ground. And we seek to identify and share realistic ideas for improving access, engagement, and fairness in asylum appeals. Methodology is built very much around our ethnography, which involves sustained contact with the people involved in a particular process or setting, as well as writing up our observations in a self-reflective and thorough manner. And in particular, our approach to ethnography has involved hundreds of observations, in-person observations of asylum appeal hearings. Including a previous British project, we've observed over 800 asylum appeal hearings. We've interviewed over 140 appellants, legal representatives, as well as a small number of judges. And we've conducted this research in a variety of countries, including Italy, Greece, and the UK for the interviews, and then Austria, Belgium, the UK, France, and Germany for the observations. We've also conducted some survey work, which has involved us sitting at the back of courts and filling in surveys or questionnaires related to the behaviour of the various parties in the hearing in France and Germany and the UK. But the majority of our work and the majority of our data is actually qualitative. So we've been spending a lot of time with our diaries, coding our data and working out patterns and coming up with arguments based on our qualitative data. Now, it's fair to point out that ethnography is limited and partial in the perspectives that it generates. It's subjective to an extent and depends upon the influence of the observer, including their life history and their positionality. What's more, in the particular context of our research, we faced various limitations because not all of the courts that we wanted to allowed us in, and we didn't have access to the paperwork for lots of the cases. So what we were able to see from the hearings was just a snapshot, really, from the public area of the hearing rooms, it was just a snapshot of the whole story of the case. We often didn't have access to the outcome of the case either, so we're very much focused on what happened during the hearing. It gives us quite a tight lens onto this process, which can be productive in itself, but what I want to recognise here is that there's lots of elements that we weren't able to take into account either. So our approach is socio-legal. It's not a pure legal analysis. We believe in the value of interdisciplinarity and conversations between different perspectives. So what we've done here is to adopt a geographical and anthropological and socio-legal perspective on a legal process. And our hope is that this has generated interesting and provocative insights into this process that will have broad applicability and broad reach to various disciplines. So the structure of the rest of the presentation. On the next slide, I'm going to talk a little bit about some of the differences between the hearing processes in different European countries. And then there are three main sections to the talk. The first concerns access, so challenges that appellants faced in accessing their appeals. The second concerns engagement, and in particular, the ability of appellants to concentrate and understand the appeal processes that they're going through. And then the third part of the talk involves fairness. I'll draw attention to some concerning aspects of unfairness that we saw in the hearings, and then we'll discuss judicial styles and discretion and where the boundary lies between unfairness and judicial style. Differences between hearings, and there are a variety of differences between the hearings and the hearing centres that we went to. So some countries have a centralised court structure. That means one court that's really hearing all these asylum appeals for that country. That's the case for France, for example, and Belgium. Whereas other countries have a decentralised process where there are multiple courts in different regions that are hearing those asylum appeals. For example, in the UK and also in Italy. Now, those differences give rise to a different texture, a different feel in the hearings. So you're likely to get the centralised courts in large cities, large urban areas, potentially capital cities, where there might be and where courts might actually support specialised services like legal services, like interpretation. In some of the more decentralised processes where courts can be a little bit more rural, you can run into differences and deficiencies in the availability of legal expertise in those areas. And that came out in our data in terms of the proportion of appellants who were able to find legal representation in their hearings. Often they were less able to find legal representation in the more remote areas, the more remote courts. Another key difference between the types of hearings that we saw was between public hearings and private hearings. Now, some countries by default would have a public hearing. Now, there may well have been a process in place that allowed the appellant to opt out of that. But in other countries, the default was a private hearing, and we weren't, as researchers, for example, allowed into the hearing. So in Italy, for example, we weren't allowed into the hearings, and that's the norm. That's the way it is. Whereas we were allowed into the hearings in France, Germany, and the UK without any problem. And there are different legal principles at play there. We're going to come back to that question of the publicity, the publicness of the hearings later in the talk. Another difference between the hearings in different countries was whether or not the case was heard from scratch. Now, this might be a function of the legal rules in the country that requires judges to focus in on a particular issue, the issue that's under disagreement, or it might require judges to actually go through the entire process. Or otherwise, if it's not in the legal rules, it may be that judges have a predilection for going through the entire story or just focusing in on particular issues of disagreement between the parties. But that gave a very different feel to the hearings as well, not only in terms of length, some of the hearings were much longer, but also in terms of the way that the judge and the parties approached that hearing. And then some hearings were in person, where the appellant would be present and there would be a legal event. Other hearings are on paper, which we weren't really able to observe, but obviously it makes a huge difference whether there's a legal event there. Some hearings were in specialist courts, courts that were designed to hear asylum cases, whereas other asylum appeals were heard within the administrative law structure that existed in the country more generally. So in Germany, for example, the hearings were being heard by judges who might be dealing with building law, building regulations, or other administrative legal issues, perhaps later that day, or perhaps they were much more familiar with that because of their career trajectory. And then another difference concerned the number of judges involved. So in France, for example, we saw multiple times that applicants would come in front of 3 judges, and that changes the dynamic. It's not always the case in France because there are different tracks that the claim can go down, including a single judge track. But frequently, cases do come in front of 3 judges, and then the dynamic of the hearing changes markedly because the judges might be consulting with each other and sharing out their questions during the appeal. So these are important questions. These are important differences. To what extent they matter, I think it's an important question. To what extent should we or could we be talking about a genuinely common system of asylum appeal adjudication in Europe? I mean, I think it's important to point out that judges we spoke to were more or less allergic to the idea of a uniform appeal process that looked identical between different countries. And they cited strong arguments against that, including arguments related to sovereignty. The national independence of the judiciary could be infringed if we try to pursue a universal standardized system of asylum appeals in and across Europe. But at the same time, if we're to live with these sorts of differences, to what extent does that matter? And are there ways that we can transplant good practices and generate dialogue, nevertheless, between different systems in different countries? Access, which I'm taking to refer to the challenges of access that applicants face when they're accessing the legal protections that asylum hearings can offer. The period before the hearing, which could be quite significant, could be a year or more between the initial decision and the appeal, was a period where applicants often had to navigate various different practical difficulties of access, some of which might include finding a legal representative, forming a relationship with a legal representative, and trying to develop a relationship of trust with a legal representative. Now, when we're talking about fairness and we're talking about justice, it's also important to recognise that those applicants who are within Europe are already beyond some of the really important and significant sources of unfairness, namely border controls, international border controls that operate and insulate Europe from the rest of the world. Europe's numbers of asylum applicants are low in comparison to other countries globally. Is to what extent can we be talking about justice and fairness in this system, which is just one small contextual aspect of a much broader set of border controls and injustices that affect migrants globally? Challenge that applicants face is to do with the housing situation that they find themselves in whilst they're preparing for their hearings. One applicant told us, "I cannot sleep or eat. By the end of the week, you're out of food. I walk everywhere." In particular, this applicant struggled to find privacy, both to prepare for his case and more generally. "They put me in a room with another person, so I don't have a private life," he said. "It's a big room, so you can sleep 2 people in here, but you need a private life. This can go on for months and months, and I'm dealing with the stress." So there's a difficulty around privacy, especially in government-provided accommodation for applicants who are preparing their cases. And this can be especially acute, some of these difficulties, in immigration detention. One lawyer told us of a client that they had who was in immigration detention. And he said, "Oftentimes my clients say, 'Do you have this or do you have that?' But this one client said, 'Oh, it's back in a drawer somewhere. I think I do have that.' But he had no one to go and start searching through all the papers to identify what he was looking for. And he could not do it himself because he was in custody." Oftentimes, the lawyer continued, people would be able to present a much stronger and more cogent case if they weren't in detention. They had better access to representatives and to information and to the outside world. So preparing for an asylum appeal whilst in detention can also be extremely challenging. But what I want to do, what I want to focus on this slide, is the effect of the waiting period for an appeal date to come around. Now, sometimes under certain conditions, that waiting period can actually be productive for the applicant. They can, for example, learn the language and begin to understand a little bit more about the legal process that they're facing. They can also begin to heal a little bit from trauma, potentially, and be able to speak about their experiences a little bit more, maybe achieve disclosure of certain traumatic experiences that they've had. They may also be able to use the time to collect evidence and prepare for their case, although one of the problems with that is that some evidence might fade. I'm thinking here about scars and other physical evidence, which might fade over time, meaning that a long waiting period is not good in terms of the generation of evidence. More commonly, though, against those arguments that suggest that it can be productive to wait a little bit for your appeal, more commonly, appellants were very frustrated about waiting for their appeals and found the period of waiting problematic. In particular, there was concern amongst our interviewees, the appellants that we interviewed, around forgetting aspects of their case, aspects of their experiences because of the amount of time that they had waited. They were concerned about that. And it was common within hearings to hear appellants say that they don't remember and that they'd forgotten. There was a deep fear that they would contradict what they'd said potentially numerous years ago during their initial government interview. And the way that judges responded to this forgetfulness was also interesting and variable. Sometimes forgetfulness could trigger judicial anger. One judge was questioning an appellant whose business had been contracted by the government to carry out work that the Taliban opposed. He received death threats from the Taliban and his father was killed. The judge was asking him details about his father's death. Where did they find him? What happened? The judge said. Surely you remember when your father died. But Nicole, who was taking the notes at the time, observed the appellant says he simply does not remember. The judge seems to take this very personally, as if it is a direct insult to him. He gets up from his seat and sits back down in an angry gesture and starts yelling almost at the top of his voice. It's 20 years ago that my father died, and I remember everything, exactly, every detail. This is complete nonsense. So the judge was clearly very frustrated about the lack of ability of the appellant to remember. And one of the aspects of this is that the judge was skeptical about the appellant's narrative and that it might be a fabricated claim. So there's clearly a real dilemma here for judges about how to handle issues of memory loss and instances of memory loss, given that there's a possibility of fabrication of a claim. How do they balance between empathy on the one hand and their skepticism on the other? Very difficult and challenging area. Another twist to this issue of remembering, however, was that we sometimes saw issues of what Nicole called in her notes, over-remembering, which is where appellants seem to recall things in such precise detail that also provoked the suspicion of the judge. In one case, the judge said, that is exceptionally detailed. How come you know this in so much detail? Clearly being suspicious of the account that was provided. In another case in Berlin, how come you can remember the exact dates of the demonstrations that you attended? So again, the judge was skeptical about the ability of the appellant to remember. And one particular question that we could pose here is in relation to appellants taking notes into the hearings. We did see appellants take notes into the hearings occasionally, but we also saw judges respond very negatively to that. In one instance, the appellant was asked to put their notes away because the judge explained, you should be able to remember it, you should be able to recall it. So that would be an interesting conversation to have. Should appellants be allowed to take notes into the hearings to support their testimony? Other challenges. They often look out of place in hearings. And one of the reasons for that is that many of the actors involved in hearings are repeat players, whereas they're one-shotters. They only do this one time, so they can often be disorientated. Now, our interviews and our data illustrates is that the court is experienced by the appellant, not necessarily in legal terms, first of all, but first and foremost as a place. And thinking about the court as an onion with various different layers, it's only actually at the very center of the onion that the judge is encountered and that the legal process itself begins. Before you ever get to the judge, before you ever get to that legal process and to the hearing room, the appellant goes through a series of encounters and meets a series of individuals who are involved in this process, including secretaries, clerks, and ushers. And so those secretaries, clerks, and ushers actually have a disproportionate effect of establishing the tone and establishing the atmosphere of the centre before the judge is ever reached. And security staff in particular are influential in this regard, because they're the very first outer layer of the onion, if you like, that the appellant comes across and that the appellant encounters. Now, we heard of and observed various different types of approach that security staff would undertake. On the one hand, security staff could be excellent. Security at most hearing centres we visited functioned a bit like airport security, ushering appellants through metal detectors one at a time, putting some back and questioning them, and allowing others to go through. The security staff are not generally legally trained, but they're there to make sure that the environment of the court is safe. And some security staff would smile, they would put the appellants at ease by perhaps making a laugh and a joke. They would turn the security process into a game for children. One appellant even said, "I felt confident. I met one security guard who was very helpful and he gave me confidence. I felt I can do this," which illustrates how important security staff can be in setting the tone for the appellants. On the other hand, we also heard of security staff who shouted at people while they were waiting, made them take their pushchairs up the stairs even though there was a lift, and made appellants take everything out of their bags unnecessarily. "You're just cattle," one British clerk told us in describing the attitudes of security staff at one centre. "It's a very, very bad experience," one African appellant told us. "You feel like you're a criminal because you see the guard and then you talk to the judge and they don't believe what you are saying." Now, the significance of that appellant's testimony is that they made a direct connection between the security staff and the judge. So it was clear that the security staff and the way that they influenced the atmosphere and set the tone for the hearing event was significant for that appellant and how the appellant perceives the judicial process and the judge. So one way to think about this is through the lens of atmosphere, this concept of atmosphere, which is a holistic concept. It includes body language, busyness, noisiness, friendliness, architecture. And we argue that this concept helps to understand the appellant experience, because when we think about atmosphere, we're not breaking it down into individual categories like the legal experience or the spatial experience, which are ultimately conceptual categories. We're actually approaching it in the way that the appellant might approach it and experience it. It's a concept that does not make assumptions about what is important and what is not, and places a good deal of emphasis on multimodal experience. And the types of questions that arise from this aspect of our data collection include: what influence can supposedly peripheral actors in the process influence? How do they influence the hearings? And secondly, what, if anything, can be done to improve atmospheres in hearings, such as, for example, specialist and continuous training for security staff? Communication and communicating in hearings. Now, there's a large literature already on interpretation, and we also noticed that interpreters were central to hearings. The idea that an interpreter is just a mechanical translation, an exact translation, without exerting any agency over that process is clearly false. And what we were interested in and what we observed was the different resourcing levels for interpretation in different countries. Some countries it seemed to be relatively okay, but noting that interpreters everywhere have a difficult job. But it's to find their own interpreters and to remunerate those, to pay those interpreters themselves, which produced various problems. So applicants might well find interpreters that weren't professionally qualified, interpreters that hadn't done it before, interpreters that went into the hearings with them and needed orientation from the judge every time. They needed to have the process explained to them, and they sometimes behaved in inappropriate ways, such as not translating everything or interjecting with their own opinion. This is one lawyer in the Italian system. Many times the translator understands less than the other party. A judge, they empathize too much with the story. Sometimes they say, "Oh yes, it's true, it's true." Another judge, some women come to translate for their sons. It happened to me 3 times. It's obvious that when the mother comes to speak on behalf of their own son, she would tend to say mostly her own opinions. So there were serious problems around the Italian provision of interpreters during the period of our research, 2017, 18 and 19. Even outside of Italy, though, where interpreters operated, we saw instances of questionable behaviour by the interpreters. Now, that's not to say that this was uniform at all. It's a very tough job and it was mostly done very well. But in the interests of identifying difficulties and potential improvements, that's why we're focusing on some of the problems here. In one case in Berlin, we noted that the interpreter often tries to forcibly insert his own opinion and often does not cross-check with the appellant, but responds to the question himself. And the judge only picks up on it sometimes. During the same case, we observed that the interpreter answers without asking the appellant. The interpreter asks a further question to the appellant independently, but does not interpret what the appellant says. So this is clearly an extreme case, but we also came across instances where the interpreter would respond for appellants, correct appellants. In one instance, the judge said, "Did the appellant say that, or did you say that?" in Munich. And the interpreter said, in response to the judge, "Well, the appellant said something about the last president of Afghanistan, but it was factually incorrect." So what they'd done is that they'd corrected it before interpreting it for the judge. Other interpreters told us that they don't translate the legal talk between the judge and the legal representative because appellants aren't interested in that and they don't understand it anyway. Other interpreters gave advice to the appellant. For example, in Germany, we saw an interpreter tell the appellant, "Oh, no one ever listens to the transcript back again in the hearings." No, it's not true. Some people do listen to the transcript back again at the end of the hearing. But the appellant took the interpreter at their word and refused the opportunity to hear the transcript back again at the end of their hearing. Interpretation is not the only challenge to communication, though. There were various other challenges too, including interruptions. Now, there were some interruptions that came from the public gallery, and some were intended. So occasionally an associate, perhaps a relative of the appellant, would interject and try and tell the judge something. "Sorry, but I have to tell you, this was mistranslated at OPRA," someone said in the French National Court, OPRA being the government department that made the initial decision. And the president replied in a neutral tone, "I'm hearing from your sister now." And the woman said, again, "I'm sorry, but I just needed to say that because it wasn't clear." And then the judge got very angry and said, "Oh, it's very clear, all right." And after that point, the judge's questions were short and sharp, and our notes suggest that they were quite mean in their style as well. So it was often, some judges would accept it. Some judges would be fine to have interjections from the public gallery, but other judges would respond in a very negative manner. Other interruptions from the public gallery were not intended. They were accidental. So we saw phones ringing, for example. We saw numerous school and college visits, especially in the French court in Paris. We heard examples of inappropriate giggling between two legal representatives of the government that were in the public hearing in one instance, and at various other times laughing in the public gallery, which was obviously disconcerting, sobbing outside in the corridor, the noise could still be heard in the hearing, shouting from the corridor and laughing from the corridor as well. So not only the public gallery, but also the immediate space around the hearing, especially when it's very busy, could intrude onto the hearing space itself. And then there's the question of children in the hearings. Now, although appellants are advised not to bring their children, sometimes it's unavoidable and they will end up bringing their children with them. And then that poses a dilemma. If you bring children into the hearings, let's say that the child is 4 or 5 or 6 years old, then they could end up shouting, they could end up wandering around, making a nuisance of themselves, crying, distracting the mother. And if there are multiple children, which we saw sometimes, maybe they would fight as well and begin squabbling with each other. So that could be distracting. Another problem with having children in the hearings is that the mother or the father or whoever is looking after the child, but it was usually women, would be worried about disclosure because the child might understand some of the things that they were saying, especially in the context of domestic violence cases. So it would become very difficult. But on the other hand, the dilemma is that if you put the child outside the room, then we saw appellants get very concerned about what was happening to their child outside the room. They really wanted the hearing to be over as quickly as possible because they wanted to be back with their child. We saw children getting instructed because they were put outside the room. We saw security guards very much struggling to look after and quieten down children in the corridors while their parents were in hearing rooms. So it's a very difficult situation. So some questions around communication. Is interpretation properly resourced? And if not, what happens? And in particular, from our perspective, because that question's already been asked, I think it's very interesting to think about the spaces for interpreters within court complexes. Do interpreters have a space that they can retreat into, a space of their own within the hearing? Sometimes they did, and sometimes they didn't, depending on the hearings that we saw. And then there's questions around publicness. Should hearings be public by default? Now, there's usually an opt-out option for applicants in a system where the hearings are public by default, but is the opt-out option enough? Do applicants understand that they have the opt-out option? Do they feel nervous, even if they can't point to a particular sensitivity within their case? Do they still sometimes potentially feel nervous because there's a public presence there, especially if that public presence might be distracting or unruly? And then there's questions around childcare. Should there be childcare provision at asylum appeals? And if so, what form might that take? Could hearing centres form partnerships with nearby creches, for example, so that applicants who are forced to bring their children can drop them off at a nearby creche? Would they even do that? Would applicants do that? Could a play worker be employed one day a week at hearing centres, and those applicants who have unavoidable childcare responsibilities be scheduled for those days so that the play worker can properly look after the children, rather than expecting security guards to do it as a kind of informal and unregulated aspect of their work? So we move on now to engagement and the ability of applicants to engage appropriately and fully with the hearings that they're involved in. One of the things we noticed, and we explore in this paper in a Journal of Law and Society, is that various countries were under pressure to speed up their asylum appeal processes. And actually governments seemed to be using the period of moral panic around asylum seekers entering Europe during 2015 and 2016 to push through reforms in order to streamline asylum appeals. So in Italy, we heard about the use of various different innovations to streamline the process, including getting rid of a whole layer of appeal protection. In the UK, we heard of tribunal caseworkers that were employed to take on some of the duties, to take some of the duties off the shoulders of the judges in order to protect judicial time. In France, we saw a continuing rolling out of the triage system, where fewer and fewer cases went in front of 3 judges. More cases went either by ordonnance, which is on the papers, or in front of just a single judge. And various other examples of this type of policy streamlining as well. But we became a little bit concerned about the speed of hearings within centres. So just taking France as an example, there would be often 13 cases a day that the judges would hear. Often they'd be bunched so that there would be similar cases, i.e. cases from applicants with a similar nationality in those hearing rooms. And there were about 40-minute slots given over to each hearing. And it could put pressure on the hearings at the end of the day. There could be fatigue setting in by the end of the day. We heard of judges who became a little confused. Oh, did I say that? And did I already tell you that? Or was that the previous hearing? And we also became a little bit concerned about abruptness in the hearings. Now, for judges, the legal conversation and the legal analysis might be over towards the end of the hearing, but the applicants might not understand that. And we saw numerous examples of judges just saying, thank you, we're finished, quite suddenly, at least from the applicant's perspective, and applicants being taken aback, surprised, disappointed, and angry as a result of the abruptness of the end of the hearing. The applicant seems angry, Nicole wrote, this time a German example, when the judge had finished. The interpreter just shrugs, takes their papers and approaches the judge's desk to have it signed. The judge signs it, gets the bundle, says goodbye to the room and leaves, but the applicant storms out, very angry. Now, one of the issues here is that the applicants sometimes are saving testimony, saving aspects of their talk or aspects of their narrative, and don't realise that the hearing is coming to an end, and then they feel as if they've not shared some of the most important parts of their process. And we saw applicants outside the hearing rooms discussing with their legal representatives or others that they were associated with and saying, oh my gosh, I didn't say this, I didn't say that, and looking very stressed as a result. So from a judicial perspective, it's difficult balancing that, because they need to be efficient. They might well have reached clarity in their own mind, so there's not any particular reason to continue with the hearing, but they nevertheless need to balance that need for efficiency with a need for empathy. One way we sometimes saw that was effective in doing that was for the judge to finish with a kind of human touch. So it could be quite a firm finish, but to say something like, good luck with your running training, or good luck with the marriage preparation that's coming up. So relating their finishing off to something human that had happened earlier on in the process, that could be quite an effective way of doing it. There were also challenges surrounding concentration, not just of appellants, but also of judges. We sometimes heard from judges and we heard judges saying towards the end of the hearings, actually, I'm flagging, it's been a long day, it's difficult to concentrate over this period of time. One judge in Augsburg told us, I do get bored with asylum hearings sometimes, and it makes you careless. So that's a concerning thing for a judge to have said. Appellants too can struggle with concentration during a very intense process. Some appellants were in physical discomfort. Appellants do have higher rates of physical disability and physical ill health for their age group than the population at large. In one instance, we saw an appellant in the UK come into the court doubled up in pain and spent the entire hearing bent over the desk with his head on the table and only whispering replies. I have severe pain, I cannot speak more at the moment, the appellant said. And they actually said they don't want to continue, but the judge continued the hearing. In other instances, we heard of appellants who'd gone through the appeal struggling with mental health issues, so they told us about this afterwards. One appellant said, was I there? I wasn't myself. I was sitting there and not taking it in. I didn't understand anything. I hated the whole thing. Mentally, I wasn't there. And intersecting with that sometimes, but also sometimes separate from it, didn't have to involve mental illness, but there was a clear issue of stress amongst the appellants as well. Ahead of the hearings, interviewees commonly reported sleep loss. Here's one. When you go to the court, you prepare yourself. Maybe you sleep, maybe you panic, you stress, or you will not sleep and you're in a mood that is not good. Sometimes this was associated with debilitating levels of panic during hearings. You're scared of saying anything, one appellant said. They ask you a question and you get a panic attack, and when you panic, you can't say what you would like to say. Some felt that their ability to receive verbally transmitted information was also consequently impaired. I was stressed. I wasn't even listening properly. My head was buzzing, one interviewee recalled. And another one recalled experiencing forgetfulness, which sounds very scary indeed. Before I go to that court, I had so many things to say, but when I was there, it was all completely out of my brain. I didn't remember anything because of the situation. It was really stressful and nervous. And for me, it was a really big issue. I forgot everything. So there's a question here about how to reduce appellants' stress, how to reduce appellants' anxieties surrounding this process. And one element of the response to this could be in terms of providing better information. So countries are obliged to provide some information when they issue the letter informing appellants of their initial decision, but that information could be better in most cases. So it could be beyond the minimum. For example, non-textual forms of information for appellants. For example, in terms of films or even virtual reality scans of the hearing room so that they can begin to visualize the hearing process and then it's not all unknown to them, could be very helpful. So that question about how to reduce anxiety could be an interesting one for us to take up in the questions and answers. And then another aspect of engagement actually refers to mistakes that were made in the initial process of determining the asylum claim by a government representative and a government institution. The asylum appeal offers a window, a partial window, an insight into the mistakes that are made earlier on, upstream, if you like, in the decision-making process. Now, I say it's a partial window, and that's important because those decisions that were made with no problem could have avoided the appeal process, and we never get to see those. We never get to see the good quality decisions that are made, but we do get to see some of the ones that were appealed and that are problematic in the asylum appeal. So it's not an objective measure of mistakes and errors that are made, but nevertheless, there are all sorts of insights that can be gleaned from the appeal process into the types of mistakes that are made at the government initial level. And we came across instances of translation errors, typing errors, interviewing errors, and reasoning errors. and also administrative errors, things just simply not being sent or not arriving in time for the applicant. In one instance, for example, an Afghan woman who had fled to Germany to avoid a forced marriage was initially housed in a centre for refugees, but she moved out with a friend and into a flat. When the BAMF is the initial decision maker in Germany, when they made a decision on her asylum claim, it was undeliverable because they thought that she was still living in the centre. She said that she had notified BAMF about her change of address. Indeed, according to the detailed account of what had happened that she gave in the court that we observed, she said that she'd notified BAMF on 3 different occasions. She was aware that the decision from them should have arrived and she actively sought it out. But in her words, she was told, "It's not our problem that you didn't get our letters." It was only on the 3rd time of asking that she was eventually shown the decision. Unfortunately, by the time she received the decision, the statutory period for appealing it had passed, and she wanted to appeal it because she wanted to enter an upgrade appeal to get a better level of recognition and protection than the one that she'd been awarded. But she faced the prospect of a lack of recourse to legal aid or forfeiting the right to an appeal hearing altogether because she hadn't done so within the statutory time limit. The court, where we observed what was going on, spent nearly an hour hearing her case for an extension, but at the end of this hour of talking about it, the judge did not grant her the extension and did not grant her the ability to appeal. Instead, he recommended that an appeal be mounted in full to allow her case to be reconsidered. So in short, it was a huge headache for her, a huge headache, because she then had to mount a whole separate case in order to be allowed to appeal the initial decision, which would have involved and was going to involve various different agencies and gathering of different evidence from different sources and more waiting as a result of this administrative error that apparently had been made by BAMF in the initial decision-making process. So we think it's important to think about mistakes, think about the prevalence of these mistakes, especially in light of the 30% of appeals that are upheld that I mentioned earlier on in the talk. And in particular, one of the things that we think it's important to look at is the feedback from the judicial level to the initial level. What does that feedback look like? What form does it take in the various different countries? And how can it be improved? Are there actually ways to hold the government decision makers to account, for example, in terms of performance measurements that are related to that rate of overturn at the appeal stage? Then we'll move on to discussing some judicial differences in the process that we observed. We can start off with talking about some of the bolder and more obvious sources of unfairness in the appeals process, some of which are outside the court's control. So for those appellants that are wealthy, it may be that they can collect evidence much more effectively. They may be able to pay people to collect evidence in their country of origin, for example. They may be able to pay for better quality legal representation. So some forms of unfairness, very difficult to regulate for. Other forms of unfairness we felt were more under the control of judges. So one of the norms that we came across in the hearings was judges who were impressed by appellants who made the best use of their time while they were waiting. If appellants said to them, "Oh, I've learnt the language while I've been waiting," or perhaps I've volunteered, perhaps I've got a job, in some countries that's possible, then it could be that judges respond very positively to that. One appellant said, "I learnt to swim," and the judge said, "Oh, how wonderful." Another appellant said, "I joined a choir," and the judge was impressed by that. Now, when the judge is impressed, it can positively influence the atmosphere of the hearing and the tone of the hearing, but it also more substantively, we noticed that judges who had a good rapport with the appellants were more likely at the end of the hearing to give them advice about what to do next, how to take their quest for immigration status forward in the legal process. So there were some substantive benefits to appellants who had a good rapport with the judges. The trouble was that often appellants couldn't make the most of their time, either because of mental health issues, because of childcare responsibilities, or other barriers, social barriers that they faced, perhaps a poor social network. So we were worried, we became worried about this very informal form of approval of some appellants over others as a form of unfairness. There were other forms of bias and prejudice in the hearings as well, unfortunately. I mean, it's fair to say that these were rare, but nevertheless, because of their importance, it's worth pointing out the occasional instances in which they occurred. So there was some prejudice, problematic attitudes to claims based on sexual orientation and gender identity, for example. One judge joked, "I'm surprised of the population boom in some African countries, considering that so many of the asylum seekers from there claim to be homosexuals," a German judge, unfortunately. There were also some generalizations about race and nationality, e.g. everybody from Nigeria does such and such a thing, everybody from Iran loses a passport, for example. So we saw that kind of generalization of cases as well. Other aspects that concerned us in terms of bias was around the ability of women to participate in hearings, especially when their partners were present. So often family cases would involve both a male and a female appellant, and there was a good proportion of family cases in the data that we saw. I think it was 16% in the German data, for instance. And here's an example in Paris. Only the man answers, but the female appellant shakes her head and makes gestures and noises in response to some of the questions. She clearly has something to say, but only the man answers, and he talks over her whenever she tries to speak. This is not commented on by the judge, interpreter, or the lawyer. So we felt as if there were some different difficulties around gender bias within the hearings at times as well. Social and legal studies paper that's listed on this slide explores the likelihood of judges undertaking certain helpful behaviours for male appellants and for female appellants. We actually watched for 13 helpful behaviours, including, does the judge state their independence? Does the judge check that the interpreter and the appellant understand each other? Does the judge explain to the appellant the purpose of the hearing and how the hearing will proceed, etc.? And statistically significant differences did arise in the likelihood that judges would undertake these helpful behaviours. Unfortunately, if the appellant is female, they were statistically significantly less likely to benefit from those helpful behaviours than if the appellant was male. The other big result from that paper was that female judges, all other things equal, in the UK were more likely to undertake those helpful behaviours than their male counterparts. So some forms of unfairness and bias and prejudice there. But there were also differences, judicial differences, that couldn't be so equally mapped onto a very clear moral framework. It's not as if it was very clear that these were problematic differences. It was just about differences in judicial style and judicial approach. So we came across various different examples of different judicial styles that kind of almost pose harder questions because they're more ambiguous. You can't decide whether or not these are very good or bad. These categories don't really mean anything. Rather, it's to do with these different styles that the judges use. And at the same time, they seem to be significant in terms of the way that the hearing progressed. So I'll give 4 examples of these different types of in-court hearing judicial discretion before concluding on the next slide. Now, there's quite a large literature on judicial discretion, multi-disciplinary literature on discretion. So I suppose we're talking to that literature at the moment on this slide, but very much focusing on what happens within the court space and within the hearings themselves, rather than more broadly in the whole process of the asylum appeal process. Okay, so the first type of in-court judicial discretion that we came across was self-revelatory. Some judges would provide an explanation for how they were thinking and why they were asking certain questions. They would say things to the appellant like, I'm asking this because I need to know this. I'm asking this, and if you can tell me this aspect of your story or this aspect of your narrative, it's going to help me in this way with the job that I have to do. So there was a kind of transparency about some judges, and perhaps that could have been helpful for some of the applicants. On the other hand, the transparency was also a little bit problematic at times when judges came into hearings and said right from the outset, I'm skeptical about your claim. I have these problems, and then enumerated the problems. So they were very transparent about where they were up to with their thinking, intending to tell the appellant, this is what you need to address during the hearing in order to convince me. But the effect of that, sometimes we felt, was that the appellant could be intimidated and lose faith, lose confidence in the hearing process because they felt that the judge's mind was already made up. So there were different aspects of this self-revelatory style of the judges that was operating within the hearings that we saw. Other judges would be emotional. Some judges would shout, they would raise their voices, they would use body language in particular ways, and they would vary their voices in particular ways. And that contrasted with judges who often kind of took a back seat and were very kind of passive during the hearings, impassive almost. It correlated slightly to the difference in legal systems. So in the UK, the judge is more expected to take a back seat while the parties have an adversarial relationship, an adversarial conversation within the court space. Whereas in other legal systems, the judge is expected to be more involved in the conversation. But at the same time, it didn't map on perfectly between those different legal systems. And what was interesting was how emotionally involved the judges seemed to get, and it did vary within all of the countries that we saw. And one particular aspect of this was the use of humour. Some judges would use humour really effectively to put appellants at ease and to establish the right atmosphere and the right tone for the hearings. Other judges, however, would use humour that was quite sharp, or it was intended for the other legal representatives in the room. It was clearly intended for them, or sometimes for the other judges in the room. And it could be quite exclusionary. And we felt that sarcasm in particular could have this exclusionary effect, intended or unintended, intentional or otherwise, because sarcasm generally involves saying precisely what you don't mean. And that's quite difficult sometimes for someone who's operating in a second or third or fourth language to pick up on and to understand. The third type of discretion was what we call rule disregarding discretion. So this refers to judges sometimes overlooking particular rules and at other times not doing so. For example, there was usually a rule that said that evidence for the hearing should have arrived on the judge's desk a certain number of days before the hearing itself, so that the judge can have time to consider it. Invariably though, during the hearings themselves, often legal representatives would approach the judge and say, look, I have this evidence that you've not seen, would you accept it please? And some judges would say, absolutely not, I won't accept that evidence, you've gone beyond the date. Whereas other judges would say, oh, you've been very naughty and I shouldn't accept that, but I'll make an exception in this one instance and I'll accept your evidence. And we couldn't work out on what basis that discretion was wielded. So that was a source of concern for us. And finally, the styles of questions. Some types of questions would embody certain assumptions, such as one judge saying in an Austrian conversion case, tell me again, when was the exact time that you converted to Christianity? The exact time, which made the assumption that a conversion to Christianity is a sudden event rather than a gradual one. And then other types of questioning involved bunching questions, so asking two or more questions all at once rather than spacing them out. And again, we felt that these were differences in style, but not necessarily very easy ones to form an opinion on in terms of what should be best practice, what should be considered best practice. So moving on to the conclusion, the photograph here is from the French strikes, where legal professionals involved in the French court were protesting at some of the changes that had been introduced, the streamlining changes from the government. And this was their way of saying that asylum has died. This is the death of asylum that we're seeing. What I want to do on this slide is just draw attention to 4 points in conclusion. The first is to do with the value of ethnography. Clearly, the sort of data that I've been talking about today and the insights that I've been talking about today shouldn't substitute for doctrinal work, black letter law. It shouldn't also substitute for statistical analysis of the law. But what I think it does, what I hope it does, is that it brings something complementary, which begins to open up the black box of asylum appeals in the court space and fill in some of the texture and some of the concrete practice on a daily basis that goes on in the courts. Secondly, just to note that asylum seekers are certainly not passive throughout this process. In fact, asylum appellants work extremely hard often to make this process work. They're the ones that have to gather the evidence. They're the ones that actually bring the appeal. So that's active in itself. And during the hearings, they're often the ones that have to work the hardest in terms of talking through things, even supporting the others around them in terms of the scheduling and making sure that the hearings work. So there's a lot of appellant agency involved in asylum appealing that shouldn't be overlooked. Thirdly, there are a variety of conceptual insights that arise from our work. For example, the importance of the spatial layout of the hearings. So for those of us who are working in the space of legal geography, I think it's really interesting to think about the concrete practicalities of the court space, the closeness of the corridors to the hearing rooms, and how the corridor noise can intrude into the hearings, I think is very interesting. The porosity of the boundaries of the hearing rooms and the courts to political and economic pressure that perhaps the law would suggest that it is above, but nevertheless you can see it operating at an everyday level within the court space. So there are conceptual developments. Another conceptual development is around mistakes, or the power, the license to make mistakes as a certain form of state power. We're seeing 30% of asylum appeals being upheld, which is quite a striking percentage. So how does that power get configured? How does it come about that governments have the license to make that degree of error? But then what's needed, I think, is also a practical conversation. I think that's where we're going to end up today, a practical conversation about some of the concrete practices that go on in the appeals. That's beyond doctrinalism. It's beyond also any notion of working towards a uniform or standardized form of asylum appeal. That's not necessarily the objective today, but it is just about sharing good practice, what works and what doesn't work across different European contexts and further afield, international contexts as well. So in terms of access, how can hearings be made less stressful? How can better information be made available to applicants who are preparing for their hearings? Should hearings be public? Under what conditions should they be public? Should there be childcare for hearings? In terms of engagement, are there ways that the atmosphere and the setting of the hearings can support concentration, engagement and anxiety? What should be done about the high rate of initial mistakes in asylum decision-making? What are those relationships between the judicial decision-making bodies, the appeal decision-making bodies, and the initial decision-making bodies, and how can they be improved? How can that communication be improved in the light of the mistakes that are being picked up at the appeal stage? And then in terms of fairness, what forms of unfairness exist? What types of biases exist? What can be done about those? And given that there are a whole range of different styles that judges can implement in terms of asylum appeals, which of these matter? Which of these matter? Which are academic and interesting, but which are matters for regulation and further discussion? And what I hope is that research has a role to play in all of this, in terms of highlighting good practice, highlighting poor practice, and developing communication and dialogue across international contexts. And I hope you'll find this talk an interesting and provocative one in terms of moving towards those sorts of conversations. And I now look forward to taking your questions. Thank you very much.